So hi, I'm Sherry Gray. Welcome tonight to the League of Women Voters of Saratoga County Meetup. I've got something showing on my screen here. Our topic tonight is bail reform and racial disparities in the legal system. As I stated, I'm Sherry, and Lori Dawson and I are the co-chairs of the meetups. And although Lori is not here in person, she is always here in spirit. Meetups are a way for us to come together to explore, understand, and advocate for issues that matter to us. They are focused on our members and their interests. I would like to first remind you of our upcoming league events, which can also be found on our website, LWV Saratoga. We are pleased to announce the return of the LWV Saratoga Holiday Party. It will take place on Thursday, December 8th from 6 to 9 p.m. at the home of one of our board members, Chris Alexander, along with her husband, Peter Martin. He's another member of LWV Saratoga. It will be a potluck with dinner with a twist. Please see the website for further details along with the address and further information. On Thursday, January 12th, a co-sponsored program on Zoom will present Religious Medical Systems and Bodily Autonomy, a Community Conversation. I think, Barbara, did you bring this to us? Barbara?
I think so.
I had to unmute, sorry. Yeah, I did. That's the 4 leagues in the Capital District are getting together to talk about that issue of the merger of sectarian and non-sectarian hospitals and how that'll affect access to reproductive rights and end-of-life choices, other aspects, LGBTQ plus services. So we hope that everybody will join us, and we're putting together a panel of speakers.
Thank you, Barbara. Not to put you on the spot, but I knew you'd be able to answer that. Our January meetup will be a discussion of new or changes to the New York State League positions. Positions are the essence of what the league can support and advocate for, and can be viewed on our website by clicking on Positions on Issues. So just as a reminder, please mute your mics on your computer and feel free to use the chat function for any questions or comments you may have. You can also use the raise hand function to ask a question. I would like to thank Linda McKenney for acquiring our speaker tonight. And Linda will introduce our speaker, Catherine Hubbard.
Okay. Just before, in case I forget, you might want to, up in the right-hand corner, if you're not used to doing this, where it says view, you might want to use speaker view. That way you'll only see the person speaking instead of everybody's face. And it also make it easier to see. Catherine's going to show us the PowerPoint, so it'll be easier to see that. And then when we get into the Q&A at the end, you can switch back to gallery view, and that way we'll be able to see who's raising their hand. So this came up because many of us have talked about this. New York State adopted a law ending the assessment of cash bail in most cases involving misdemeanors and nonviolent felonies. And the law's purpose was to reduce the risk that someone would be jailed because they could not afford to pay for release. And this unnecessary use of incarceration can have a profound effect on people's lives. But this leaves a burning question, one that came up a lot in the recent candidates' advertisements. For one, does cashless bail lead to increased violent crime? So we are happy and grateful to have Catherine Hubbard here, who's going to help us better understand the intricacies of cashless bail and injustices in the criminal justice system. She's the Deputy Director of Litigation at Civil Rights Court Her work focuses on challenging the criminalization of poverty, particularly wealth-based pretrial detention. And as a member of the San Francisco Public Defender's Office, her work culminated in the landmark Humphrey decision in which the California Supreme Court struck down the pervasive practice of courts setting bail money without considering an individual's ability to pay. Catherine, we're so happy to have you here. Welcome and take it away.
Thank you so much for that lovely introduction, and it's wonderful to be here with you this evening. Just a quick note of warning before I get started. I have a 1-year-old who should be going to bed soon, so if you hear someone screaming bloody murder in the background, everything's fine, but she has some objections to bedtime. But yeah, so I have been working on this issue of money bail for many years now, and it's something I feel very passionately about and that I'm really excited to talk to you all about, as I know this is a very topical issue in New York right now. So my plan is to start by giving an overview of the American bail system in general, and then towards the end of my presentation, I'll talk more specifically about the bail reform that has happened in New York and some of the backlash to that, and I'll finish by opening it up for questions. So let me share my screen with you all. Nope, not that. Oh, hang on a sec. That's not right. Screen. Are you seeing a? Sorry. Do you see the PowerPoint?
I see a purple screen that says bail. What is it and how does it affect us?
Okay, perfect. That is what you should be seeing. Yes. So bail, what is it and how does it affect us? So the first point to make about bail is that traditionally and historically, bail has meant release. Bail as a concept has existed for many, many years, since the Magna Carta, and it's in our Constitution and is a huge part of the criminal legal system in this country. But historically, it meant release pretrial. And the Supreme Court, in this case, United States versus Salerno, highlighted the importance of bail in its historical sense, meaning release. And this is a quote from that case. In our society, liberty is the norm, and detention prior to trial is the carefully limited exception. So both historically and under Supreme Court precedent, bail is meant to be release pretrial for all but, in all cases, except a very limited number. However, that is not the way that bail is actually currently operating in almost every jurisdiction in this country. So the current state of bail nationwide is that over 10 million people are admitted to local jails every year. And every day, over 500,000 people are detained in local jails. An additional 64,000 are detained in the federal system. And since 2000, pretrial detention has driven a 95% growth of the jail population. So what we see every day is that bail is absolutely not the carefully limited exception, or that pretrial detention is not limited in most jurisdictions, that actually thousands and thousands of people are being detained pretrial when there's a presumption of innocence, and the government has not proven that this person did anything wrong. And this pretrial detention has just, as the statistics show, been a huge driver of mass incarceration and the growth in the US jail population over the last couple decades. And what's really important to know about pretrial detention is that a huge percentage of it is being driven by cash bail. And I think we all have sort of a general familiarity with how cash bail works, but basically, just to quickly go over it, it's if you're arrested, you go in front of a judge. The judge either has a bail schedule, which is a list of offenses with a dollar amount next to the offenses. And the judge looks at the schedule and says, okay, you were arrested for that. The schedule says you have to pay this amount for release. That's your bail amount. Other jurisdictions, there's no schedule, but a judge has discretion to set bail at whatever amount they deem appropriate. And whether it's set by schedule or set at the judge's discretion, it's a dollar amount that if you can pay, you'll be released. And if you can't, you're stuck in jail. And most of the time, that amount is set without an adversarial hearing. So people are not represented by counsel at the initial bail determination. There's no one there to argue for why they should be released. Judges often rely on things like rap sheets with criminal history, and defense attorneys will tell you that those are often full of errors, and that when they can get in front of a judge, they can say, they can make argument for what those errors are, and explain things that are happening in the person's life and in their history that make them a good candidate for release. But that often doesn't happen right away. Sometimes it doesn't happen at all. But that initial bail determination is usually set at a very perfunctory hearing where a judge is just making a pretty quick decision about whether the person will be released or whether money bail will be imposed and at what amount. As I said, this is sort of ahistorical, the way that our system works now. Historically, bail was actually not an upfront payment. It was an amount that a person would owe if they failed to attend court. But in general, most people were released with no upfront payment. And that really applied to the vast majority of people. Pretrial detention was very limited. There was a major shift in around 1900 with the creation of commercial sureties. Prior to that, sureties were a person who knew the arrestee and would guarantee that they would pay the court if that person didn't come to court. And then around 1900, in San Francisco, some people came up with the idea of doing that for people they didn't know, but charging them a fee in order to be their surety. So that was the invention of the commercial surety industry, usually referred to as bail bondsmen. And today, the US and the Philippines are actually the only countries on earth that permit a for-profit bail industry. So the US is a big outlier in that way. Another way that the current system is just very ahistorical is just the sheer number of people who are being detained pretrial. The proportion of felony pretrial releases with a financial condition has grown from 37% to 61%. So now most people charged with felonies have some sort of financial condition of release that they need to satisfy in order to get out of jail. So pretrial detention causes really significant harms to people. And I'm going to talk about some of those in this next part. one of the most significant harms of pretrial detention is that people who are in jail because they can't afford to pay money bail often lose their jobs and lose housing. 23% of people jailed pretrial lose housing. A study found that pretrial detention cut men's earnings by 40%, even 3 to 4 years after a bail hearing. And pretrial incarceration increases likelihood of employment disruption by at least 700%. And these harms are pretty intuitive. If you can't get out of jail, you can't attend your job, obviously, and most people don't have jobs where you will continue to be employed and get paid if you're in jail for months or potentially years. So people lose their jobs. It's much harder to find a new job if you're eventually convicted. So it's a really significant disruption to employment to be detained pretrial because you can't afford to pay bail. It also often, sometimes, as the statistics show, result in loss of housing. I had a client who was jailed pretrial for a long time before we eventually got him out, and this was in San Francisco, where housing is extremely hard to come by, especially affordable housing. And he actually had affordable housing in a senior living facility before he was arrested on charges that were eventually dismissed. But in the meantime, he had lost his space in this senior living facility. And by the time he got out, the wait list to get back on was years long. So he still hasn't been able to move back to San Francisco because he can't find housing. So he really he lost his home as a result of his arrest and not being able to pay bail to get out. So bail has really significant effects on jobs and housing. It also separates people from their families. More than half of people detained pretrial are parents. And it's hard on parents, obviously, to be separated from their children. It's also really hard on children to not have their parents. Children with incarcerated parents are more likely to experience developmental delays, be aggressive, drop out of school, end up incarcerated themselves. So it really harms the whole family often to have a parent in jail who can't afford to pay bail. And yeah, it can just be extremely detrimental to children's development. And cash bail exacerbates racial disparities in the criminal legal system. So on average, money bail is 35% higher for Black men and 19% higher for Latino men than it is for white men. Black people are 66% more likely than their white counterparts to be jailed pre-trial. And also white people are much more likely to be able to pay bail. So the average wealth for white families is 7 times higher than the average wealth for Black families, which means it's much more likely that that the family will actually be able to get their loved one out of jail if money bail is imposed. So bail really is wealth-based discrimination. It's the government allowing freedom for people who can pay an arbitrary amount of money and jailing people who can't afford to pay that amount. And kind of the most pervasive thing that, the most pervasive myth that is told about cash bail is that it makes us safer. And it really doesn't, for a couple of reasons. One of which is just that actually people do not forfeit money bail if they commit a new crime while on pretrial release. So bail doesn't create any financial incentive to not commit crimes because you won't lose what you've paid if you commit another crime. And there's really significant empirical evidence actually showing that being detained pretrial increases likelihood of committing future crimes, or at least being arrested for future crimes. And, you know, there's many reasons why that might be true. Possibly the disruption to life that that pretrial detention causes, and, you know, makes it harder to get a job, and all these things we've talked about already. But yeah, pretrial detention increases likelihood of rearrest, which is not something that you hear talked about much by politicians who are supportive of money bail. It's also not very effective at the other purpose of bail, which is ensuring court appearance. So one of the reasons why it tends not to be all that effective at ensuring court appearance is that the vast majority of people who are able to get out of jail by paying bail do so by paying a bail bondsman. They don't pay the court. So, I mean, just backing up a little bit, there's this idea that how bail works is that you put this money down and it creates an incentive for you to go to court. And then if you make all your court appearances, then you get that money back at the end of your case. And that's just not true for most people, because most people get out by paying a bail bondsman. And when you go through a bail bondsman, you're paying a non-refundable fee to a company. And once you pay that fee, you're not going to get that money back no matter what. So there's not that financial incentive there that people generally think that bail creates. And empirical evidence shows that secured bond actually decreases the likelihood that people appear for court. And there's also pretty substantial evidence showing that that unsecured bond, where a person is released right away, but will have to pay the money down the line if they don't show up to court, is as effective or more effective at getting people back to court than secured bail is, where you have to pay up front. There are a lot of studies showing that court date reminders are the single most effective way to reduce failures to appear in court. So if you release someone not on money bail, but with a phone number for them that allows you to send them text message reminders of their court date, that's actually the most effective way at getting people back to court. And it's kind of mind-boggling now that we can get text message reminders for our doctor and dentist and pretty much everything. I'm getting text message reminders all the time, but a lot of courts have not implemented text message reminders, even though it's just an incredibly effective way of getting people back to court. It's important to remember that most people who don't show up for their court date have not fled the jurisdiction and hopped on a plane to Mexico. They're around, and they just haven't gone to court for a variety of reasons. Maybe they forgot because they didn't get because they lost the paperwork with the court date on it, and they don't get a reminder about the court date, and so they just forget. There are other reasons, like not having childcare, not having good transportation to court. But really, it's a very rare case where a person actually flees the jurisdiction, and generally people will go back to court if there's something that helps them do that. And text message reminders are just the most simple, straightforward way of increasing court appearances. So we know that cash bail contributes to mass incarceration by jailing people who can't afford to pay this arbitrary amount of money. The US has only 5% of the world's population and nearly 25% of the world's prisoners, at least 4.5 million people under supervision of some kind, either probation or parole. the jail and prison systems target poor and Black people, and pretrial detention leads to coerced guilty pleas and longer sentences. And that's something I want to talk about a little more, because I think it's really one of the most important things to take away about bail is it really drives mass incarceration by coercing guilty pleas. There's just a mountain of evidence showing that people who are detained pretrial because they can't afford to pay money bail are more likely to take a plea, are more likely to be found guilty, are more likely to receive a sentence of incarceration as opposed to some other type of sentence, fine and probation, that type of thing. And if they do receive an incarceration sentence, that sentence is going to be longer, most likely. And that's because jail is just an incredibly coercive environment. People don't want to be in jail. People want to be with their families. They want to get back to their job, to their life. Jails are not a fun place to be. So people really want to get out of jail as fast as they can. And the easiest way to do that in most cases is to take a plea and get out of jail. And that's because, the vast majority of cases are not particularly serious. And so often if you've been in jail for a couple weeks and you go to the prosecutor and say, I want to take a plea, the prosecutor will say, okay, if you plead guilty, you'll get credit for time served, which means that if you go to court that day and plead guilty, you can walk out of jail at the end of the day. So even if you didn't do the thing that you're accused of doing, the fact that you can get out of jail that day is a deal that many people find hard to pass up for very understandable reasons. But it can be it's obviously devastating if the person didn't do the thing that they're accused of. And it tends to result in all these harms down the line in terms of the sentence when you've entered the plea, just because you're probably taking a worse deal than you might have gotten if your defense attorney had opportunity to investigate your case and put all the facts in front of a jury. You're just missing out on that opportunity. So it's really important to understand how bail connects to mass incarceration more generally. Bail's the front door. And what happened, that decision of whether to impose bail that a person can't afford or to release the person has consequences that really go throughout the entire case, all the way to sentencing. The cash bail system also wastes money. The US spends $13.6 billion on pretrial detention every year, which is $38 million a day. That's money that's obviously not being spent on social services that might help people stay out of jail in the first place, would help many other people in many other ways. And it's wasting money in other ways by driving unemployment, as we've talked about, and reducing earnings and reducing likelihood of paying taxes. So it wastes money jailing people many of whom do not need to be jailed. And then there are all these, consequences down the line that take money from the government as well. Another thing to keep in mind when thinking about pretrial detention and money bail is that jails are really dangerous and unhealthy places. People who are in jail are at a significantly increased risk of physical assault, particularly sexual assault. Jails are also sites where infectious diseases spread rapidly and sometimes devastatingly. We've we've now seen this obviously with the COVID pandemic. COVID spread through many jails and killed people, many of whom were in pretrial detention, presumed innocent, and they lost their lives just because they couldn't pay bail. So pretrial detention is deadly, and in 2019 there were 1,200 jail deaths that we know of. Many jail deaths don't get reported as such. For example, a lot of places, if the person is sent to the hospital and then dies in the hospital, they don't count that as a jail death, even though it's someone who was in the jail up until hours before they died. So a lot of people die in jail, and there are various reasons for that. One is that there's little or no medical care in jails. People do not receive often medications that they need, and do not get adequate medical care. There's overcrowding and poor conditions. People are often sleeping on the floor, are not getting good food, are living in conditions that can be like just quite squalid, with blood and feces and urine nearby, spread on walls, that sort of thing. So that's a really dangerous aspect of being in jail. Obviously, there's abuse, there's violence from other prisoners as well as from guards, and just neglect of vulnerable people who need to be attended to and aren't getting that attention. There's also high rates of untreated mental illness. A lot of jails really are housing just incredibly high rates of people with mental illness. You'll hear sheriffs who are candid about the issue, calling their jails, the biggest mental health hospital in the county. And suicide is also a significant problem in jails. So who is this system serving? It's certainly not serving arrestees. It's not serving the general public because of all these wasted resources and the fact that it doesn't help with court appearance or public safety. So who is it serving? It's serving the plea machine above all. It's extracting guilty pleas from people who are detained pretrial and desperate to get out. And the bureaucrats who benefit from that, such as prosecutors and also judges who are able to clear their dockets more easily because of people taking guilty pleas and not fighting their cases and taking them to trial. It benefits the wealthy who are able to get out of jail, even if they are a public safety risk or even if they are a flight risk. They can write a check and be out of jail right away without any further scrutiny from the court. And of course, it benefits the for-profit commercial bail industry, who is raking in enormous profits through these non-refundable fees that folks are paying, something that not a lot of people know about the bail industry is that it's actually extremely rare for them to lose money when a person doesn't show up to court. So it's a highly profitable business for bail bondsmen. I'll switch now to talking about bail reform in New York now that I've given sort of a broad overview of bail generally. So I'll start by admitting that I'm not an expert in bail reform in New York. In particular, I've never worked in New York, but I have certainly, as someone who is interested in this issue and dedicated to this issue, watched and kept abreast of what was happening in New York. Because when bail reform first passed back in 2019, it was something that was really widely celebrated in the bail reform community. It was generally regarded as, one of the best laws that has passed at a statewide level on bail reform. And it was really distressing for the community to see kind of the way that it was walked back the following year, and the rhetoric that has prevailed around bail reform in New York since the law went into effect. So again, I'm not an expert, but I'll do my best to talk about it. And certainly if I get anything wrong, feel free to correct me at the end when I open it up for questions. But yeah, I'll jump in. So back in 2020, this law went into effect, ending the assessment of cash bail in most cases involving felonies and nonviolent misdemeanors. And as I mentioned, later that year, in response to criticism of the law, most of which was unsubstantiated, the legislature ended up passing amendments to the law, expanding the list of bail-eligible offenses, especially nonviolent felonies, which led to judges setting bail more often in cases where they had discretion to do so. And leading up to today, lawmakers are continuing to attack bail reform as this boogeyman that's the cause of all this increased crime, despite the fact that research and data has not shown any correlation between the bail reform law and any increase in crime. So I will get into more how the bail reform law actually works, but just to back up to before the bail reform law, how it was working was that New Yorkers who were facing minor charges, these misdemeanors and nonviolent felonies, were required to pay money bail to get out of jail. So judges would, a person would come in front of a judge and the judge would say, you have to pay X amount. People who could pay that amount were free to leave, and people who couldn't pay were stuck in jail. So many people couldn't pay even $500, or if they could, it would be a huge expense that would come at the cost of other necessities of life, like paying rent and putting food on the table, paying utilities, that kind of thing. And poor people faced these dangerous and deadly conditions in jail that I talked about earlier. And of course, I'm sure you're all familiar with the incredibly tragic story of Khalif Browder, who was, as a very young man, arrested for allegedly stealing a backpack, had his bail set at $3,000, was sent to Rikers Island, where he stayed for 3 years, 2 of which he was in solitary confinement. He faced just horrible violence, and following his release, he died by suicide. So his case was one that got a lot of attention, just because of how incredibly tragic it was, and was one of the things that really sparked this movement for bail reform in New York. So that leads us up to the actual passage of the law. How does bail setting work under this new system? So now judges have the option to set money bail in most cases involving a violent felony. So judges have discretion in cases where there's a violent felony charge to set money bail in the way that they did before before bail reform, except that they're encouraged to look at alternative conditions of release now as well, as opposed to simply setting money bail. In other types of cases, so nonviolent felonies, misdemeanors, judges are instructed to release people on their own recognizance, that's what OR stands for, or impose other conditions of release to ensure a return to court. So things like assigning people to pretrial services, if the jurisdiction has that, or other types of conditions that will help a person get back to court. The law also said that police should issue appearance tickets to people charged with some very low level offenses rather than taking them to jail in the first place. So you just get a ticket with your court date on it, and you don't have to go in front of a judge at all and go through the bail setting process. Let's see. And one other aspect of the law is that when deciding whether to release a person or to set bail, the judge is supposed to focus solely on conditions that will ensure the person returns to court. So I think there was a slide back in the broad overview section that talked about the two legitimate purposes of money bail. One is return to court, and one is protecting public safety. So this law says that judges should focus on getting people back to court and not on the public safety side of money bail, which, as I mentioned, there's not really a connection between money bail and public safety anyway. So now, as opposed to other states, New York judges can't consider the subjective view of a person's dangerousness when deciding what conditions to set. They are supposed to be looking at return to court. And this approach reflects an attempt to preserve the presumption of innocence and reduce racial biases against arrestees. So yeah, that's just an overview of the new system. What has been the impact of that system so far? As many as 80,000 people who were released under the new law would likely have been jailed on unaffordable money bail under the old system. And nearly all these people went on to pose no documented threat to public safety. And of course, for those thousands of people who were able to obtain release, that means that they stayed with their families. They were able to keep jobs, keep supporting their families through their jobs. And it has probably quite literally kept people alive, since we know jails are dangerous, particularly during a pandemic, as we've been living in the last couple of years. And we know that the crisis that's occurring in New York City's jails, where 18 people have died this year, would likely be even worse if this bail reform law had not been passed and kept these thousands of people out of jail. But as I'm sure you know better than I do, having living in New York, there's been a significant backlash and significant attacks on the bail reform law. Politicians and law enforcement officials are scapegoating this law as the reason for rising crime rates. And it's really a big concern. First of all, because there's just no evidence linking bail reform to the increase in crime. This increase in crime, I'll preface all of this by saying that crime rates are just notoriously difficult to actually determine. It's hard to talk about rising crime rates with any sort of specificity, because crime rates are very much controlled by police and prosecutors. Police are the people who decide when to arrest a person, what to charge the person with. So police are really able to make crime rates go up and down based on the choices that they make. So it's hard to even know whether an increase in crime truly is happening. But for purposes of argument, that crime rates have increased, that has been a nationwide trend over the last couple years. So crime has, or I don't know if it still has, but crime rose throughout the country in 2020. It was certainly not a New York specific phenomenon. So it doesn't make sense to point to this legislation as being the cause if it was in fact a national trend. The Times Union of Albany did a study showing that relatively few people who were released under the new law went on to be rearrested for serious offenses. In New York City, the NYPD has certainly had a lot to say about the bail reform legislation. And one particular thing that they claimed was that bail reform had led to an increase in shootings. But a New York Post analysis of NYPD's own statistics showed otherwise. It showed that just one person who had been released under the new bail reform law had been charged with a shooting. And in New York City, pretrial arrest rates remained stable before and after passage of the bail reform law. So it fluctuated between 1 and 3 percentage points up and down, and began trending downward in 2021. So in plain language, that means there's no meaningful difference in how many people were arrested before and after bail reform. And a recent study looking at all of the available data on the impact of the bail reform law just found no clear connection between the change in the law and crime rates. Despite the fact that there's just no good evidence of this correlation, various candidates and elected officials have focused on bail reform as the source of higher crime rates, instead of looking at real drivers of violence, such as economic desperation, lack of access to resources and treatment, and underinvestment in programs and services that are demonstrated to help keep people healthy and safe. The last point I really just wanted to make was about racial disparities. Any attempt to roll back bail reform in the ways that politicians are advocating for is going to have a disproportionate impact on Black people and other people of color. So a New York Civil Liberties Union report that predated bail reform found that in 8 upstate counties, white New Yorkers were twice as likely to be released on bail as Black New Yorkers. And that's consistent with some of those national statistics that I showed earlier. White people are more likely to receive lower bail and are more likely to be able to pay bail because white families have more wealth. So that was the status of things before bail reform, and it's very possible that by rolling back these reforms, we would be going back towards a situation like that, where there's such a stark racial disparity. And in particular, opponents of the bail reform are advocating for a dangerousness standard. So one of the things that I mentioned earlier was how judges right now are only supposed to be looking at what amount of bail is needed to get the person back to court, and what conditions are needed to get the person back to court, rather than looking at public safety. And so opponents are advocating for judges to look at danger, calling it this dangerousness standard. And that would allow judges to hold people who they think would commit crimes if they were released. But in our society, which is unfortunately racially unjust, dangerousness often becomes a proxy for race. Sorry, there's the baby. And then, so a Center for Court Innovation study compared bail setting in 2019 before the law went into effect and in 2020 after the law went into effect, and looked in particular at what happened when the law changed midway through 2020 and judges began setting bail in more cases under the amended law. And there was a really disproportionate impact in who ended up being detained when the law changed. So in the first quarter of 2020, before the law changed to give judges more discretion to set bail, the disparity in the rate of Black versus white arrestees who faced bail was 7 percentage points. And by the final quarter after the law changed, that disparity had tripled to 21 percentage points. So a really significant disparity as a result of the changes to the law that gave judges more discretion to set bail in cases where previously they did not have discretion to set money bail. So just sort of my last point and the bottom line about bail reform and how it's playing out at the moment is that it's really not about public safety. We know that money bail does not help protect public safety for all these reasons I've talked about. So rolling back bail reform is not going to make people safer. What it is going to do is increase the power for police, for prosecutors, and for judges. Prosecutors want to have the power to coerce guilty pleas, even from people who haven't done anything wrong. And money bail is a really effective means of doing that. Money bail keeps people in jail and makes them much more likely to plead guilty. Meanwhile, police departments are using bail reform as a scapegoat to avoid scrutiny of their own failures. And police are also eager to create a narrative about crime that results in more funding to them. So yeah, I think my biggest takeaway about the backlash against bail reform is that it's not supported by the data, the statistics, and in fact, it's bail reform makes people safer, and makes all of us safer, really, because there are too many people in jail who do not need to be there, and being in jail, in fact, ends up creating public safety issues down the line. So, so I'll stop there. I hope there are questions. And yeah, I'm eager to hear from you all. Let me try to stop sharing my screen. There we go.
Thank you, Catherine. There was one person who asked a question in the chat, so I'm gonna put I know Barb's not afraid to ask her questions, so I'm gonna let her ask her question. And then if anyone else has a question, just please raise your hand so we can do our best to answer. Barb, wherever you are.
I'm working on unmuting myself. Okay, my question is that in Saratoga County, I know that generally speaking, we have maybe 1 or 2 trials a year. And I'm wondering, does that show us that we're really not treating people properly, I guess, or that we're forcing plea bargains that really have nothing to do with guilt or innocence?
Yeah, I think that's such a good point. It's really surprising to folks who, who think of the legal system as, what they see on Law and Order, and it being, trials day after day, how rare it is for a case to actually go to trial. The vast majority of cases resolve through plea bargains. And as I said, pretrial detention as a result of unaffordable money bail is a huge driver of that. People who are released pretrial are less likely to take a plea, are more likely to take a case to trial, and are more likely to get good results from that trial. So yeah, it's our criminal legal system is now truly a system of mostly plea bargaining, and money bail is a big driver of that.
Darnell, you're up.
Okay, my question, I don't think money should have anything to do with whether a person is retained or not retained in jail. But there are people, for instance, I'm thinking of domestic violence cases where a person is arrested after, I'm just going to say man and woman, after a man beats up his wife or his girlfriend, he's arrested, he's taken to jail, and then he's released, and then he goes back and kills her. And that, that does happen. And you can get an order of protection, that piece of paper that doesn't really protect anybody. So in those kinds of cases, how would the court know that this person is potentially dangerous and give them time to kind of cool off before they release them again? I mean, how do you protect that victim?
Yeah, so that question is it's a great question, and it's why bail reform advocates are in favor of a system where people are either in jail or out of jail. So as you said, money should not enter the equation. It shouldn't be that, a rich man can pay bail and get out of jail and, go back home and continue to commit violence against his wife. If we believe that in a just system, the judge should be able to just detain a person where there's a serious risk of something like that happening. And the New York system does allow for someone who has been charged with a violent felony like domestic violence is, be detained pretrial. And that's how we think the system should operate. Now, if it's a situation where the judge doesn't feel that detention is actually necessary, there are, of course, other conditions of release that can be imposed that can address some of the underlying concerns in a way that like just releasing the person on money bail wouldn't. There's, as you mentioned, there's like stay away orders. There's a requirement to surrender any weapons to law enforcement. Those are at one end of the spectrum, and of course, conditions can increase to things like ankle monitoring and regular check-ins, things that are much more aggressive supervision of a person who has been released. But those are conditions that are actually addressing the concerns about going back and committing some kind of harm, as opposed to just release on money bail, where as I said, there's money bail doesn't create any incentive against like committing any harm. So yeah, I think the right answer for a system, a right answer for that situation is that if the person poses a substantial enough harm, they should be detained, whether or not they can pay some amount of money, and if they are going to be released on conditions that are designed and narrowly tailored to actually protect the victim's safety.
Barry has a question.
Yeah, I'm just still confused, Catherine, about the role of the judges. It seems to me that they have the power to state whether or not someone's going to get bail or not, and how much it's going to be, and they should be looking at facts. So why is this so disruptive for the judges? Even though there's no bail, I mean, they could decide, well, I don't believe that that's true in this instance. I want to set bail on this person because of past or whatever's going on. I just don't understand why the judges aren't taking this and just going with it and realizing that, yeah, for a guy that just, stole a candy bar and was running away because he feared for his life, that he needs to have, $500 in bail. I don't get it. I'm really confused about the judge area in this.
Yeah, I am too. It's something that I think about a lot as well, and I think I think what it tends to come down to is that judges have been doing things a certain way for a long time, and are used to doing things a certain way, and don't like having to change the way they do things, and particularly don't like having discretion taken away from them, which is what these bail reform laws do. It requires them to release people who are charged with these really minor offenses, and they just don't like the fact that they no longer have discretion in that type of case, and that causes them to oppose reforms that seem like very common sense. And in the course of my work, I've worked with judges who do judicial education of other judges. Here in DC, we don't use money bail at all, and so there are judges from DC who go around talking to other judges about a system where money does not enter the equation at all, and from what I hear, it's hard going even from a fellow judge to convince judges that this is a better system, one that doesn't rely on a person's ability to pay, and that releases people who are charged with really minor offenses. But yeah, it's I think what it really comes down to is judges are set in their ways and don't like not having the discretion to set bail as they see fit.
But I mean, wouldn't they just set it or not set it as they see fit? That's what I'm confused about, you know. If it's okay, so we have two guys, one guy stole a candy bar, the other guy stole a candy bar, but the guy A has, you know, a rap sheet. He's got a whole bunch of offenses, you know. Can't the judge say, okay, in this circumstance, I'm setting bail on this guy, but the other guy who just did it the very first time, the offender B, he could go with no bail. That's what I'm really confused about. You know, somewhere the judge, based upon his experience and what he sees being brought forward on the offender, can or can't set it. I mean, it's not mandatory that he not set it. It isn't, is it?
So are you asking like under the current law in New York? Like,
Under
does the judge have
law
discretion?
the one that we passed, yeah, like last year, the one that everybody is in uproar about and wants to get rid of because they're saying violent offenders are now out on the street.
Yeah, so again, I'm not an expert in this law at all, and I don't yeah, I'm not exactly sure, but my understanding is that the law actually does prohibit judges from setting money bail in certain cases. So in a low-level case like you're talking about, where the person is only charged with stealing a candy bar, that, you know, it is a policy judgment that someone who has only stolen a candy bar should not be detained pretrial, regardless of their criminal history, because it's not worth it to society to keep someone in jail pretrial for such a minor offense. And you know, I think that's a very reasonable policy decision to take that discretion away from judges. You know, prior to this, it could easily be the case that the judge looks at the candy bar case, says, oh, it's not very serious, I'm setting bail at $500, which seems like a low amount in the judge's mind, but the person can't pay $500. They don't have $500. And so they end up sitting in jail on this incredibly minor charge until they, you know, most likely take a plea to time served and get out of jail in a couple of weeks. So again, you know, I hope I'm not just like completely botching my understanding of this law, but yeah, my understanding is that like the key feature is that it takes away a judge's ability to set bail in these minor cases where the policy decision has been made that people should not be in pretrial detention, you know, for this minor offense.
Darnell, did you have another question? Is your hand still up from before?
Yes.
Okay.
I put it down and I put it back up again. Does any of the money from the bail trickle into the court or the municipality or any of the individuals at all? For instance, campaign funds or money, you know, again, that the court could use for its discretion, or private jails. I mean, does any of the money from cash bail end up going to anybody but the bail's bondsman?
So certainly not directly that I'm aware of in any jurisdiction is money that people are paying for bail going directly to the court. I think certainly indirectly, bail bondsmen are a powerful lobby and in many states, and are supportive of judges who oppose bail reform in states where judges are elected. So certainly in judicial elections, I'm sure quite a bit of money is going from bail agents to judges who are opposed to bail reform and supportive of continuing to impose money bail.
I was wondering, you mentioned prosecutors benefit from the number of guilty pleas they get. So like plea bargaining, that kind of thing benefits them. Is that just like for their record, like, hey, I got so many more guilty verdicts than you did kind of thing? Or how do they benefit?
Yeah, it benefits them in that sense that they, people are keeping track of prosecutors' conviction record. And so securing easy convictions through guilty pleas benefits them in that sense. It also benefits them in the sense that like cases where the person ends up pleading guilty just resolve much quicker. A case where they actually have to go to trial just takes a lot more resources, a lot more time. And if all these cases that are being resolved through guilty pleas were actually going to trial, prosecutors would either be working around the clock or would have to take fewer cases on. So yeah, a system of quick pleas benefits them both for their record and also for their resources.
Okay, thank you. Monica, you have a question.
I was just following up on the question about who's getting money out of this deal. And, the question about whether any of the money comes back to the government. I thought perhaps through, a small amount must be coming in through the taxes that the bondsmen are paying on the money they're making from the payouts. Honestly, somebody's always making money, and the government would not be perpetuating a process that's costing us money if somewhere along the line someone wasn't collecting, and it's not just these bondsmen.
That's a good point. Yeah. I hadn't thought of the tax angle, but you're right. Someone's always making money.
Anne, you're up.
Hi, thank you very much. This has been interesting. What I'd like to do is go back to what you were saying about plea bargains and how it creates kind of a quick turnover for prosecutors. And then you said, well, if you ended plea bargains, either the prosecutors would be overwhelmed, or they would have to take on fewer cases. Didn't quite understand that. Is there any way prosecutors can take on fewer cases, or just say that there's nothing to see here when it's presented to them by the police, or how does that work?
Yeah, so that is how our system works, is that prosecutors have tremendous discretion about whether to bring charges in a case. So the police bring a case to the prosecutor, and the prosecutor makes a decision, both if there's enough evidence there that they think a case could be successful, and frankly, a decision based on the priorities of the office. So it's the case that prosecutor offices have priorities and say, we're going to focus on like these type of case, and like this type of case we're not necessarily going to bring. So prosecutors can, you know, if it were the case that all these cases were going to trial and prosecutors' offices were overwhelmed, then it would be, you know, within their discretion, absolutely, to just stop taking a lot of the cases that police are bringing to them. They also do their own investigations into things, and they could, you know, stop investigating other cases that they're working on in order to focus on all the new cases that are going to trial. But yeah, prosecutors have a ton of discretion to choose which cases they take and don't take.
Thank you.
You're welcome.
I don't see any more questions in the chat or any more hands up. Anybody else have a question before we wrap up? We would have time for maybe one more question.
Okay, well, thank you, Linda. Thank you very much, Catherine. That was very interesting, and hopefully we get things straightened up in New York State and we don't have to have this conversation again.
I hope so.
Let's see. So this meetup has been recorded and will be available on our YouTube channel with links on our website and social media. That's both on Facebook and Instagram. If anyone wants to make sure that someone that missed it, they could watch this again. And other than that, thank you everyone for coming. And Catherine, you can maybe go kiss your baby goodnight.
Yeah.
Thank you.
Catherine.
Bye.
Thank you.
Bye.